I'm a first-year Master's Public Policy student at Humphrey. Before coming to Humphrey, I taught middle school geography for 6 years in Houston, Texas, and was a middle school assistant principal at charter school in Texas for the past 3 years.
My name is Catherine Ratz. I am a first-year student at the Humphrey School for Masters of Public Policy, and I've been teaching for about the last 8 years. I've taught in kind of all over the world, but Spain, Pearl, Mississippi, DC, worked at a charter school in DC. I was a director of operations at a charter school here in Minneapolis, and then most recently I was working at an independent school in Orange County, California.
My name is Jemima Ajuanchukwu. I don't have any teaching background. I have spent a lot of time learning on the other side. I do have a come from a family that does highly value education, so I think this will be a really interesting course to learn about it from the legal perspective of policy, because I'm a law school.
Great. Thanks, Jemima.
I'm Jim Cortez. I'm a 2L at the law school. I transferred in from McGeorge in Sacramento. Prior to starting law school, I did 3 years of special ed teaching in Alaska, then 2 years of general education teaching in Nevada and California. Between those experiences, I was in the Navy for a while. My wife was Air Force, so we were all over. We're here now permanently, hopefully. I'm taking this class because, having been a special ed teacher, I saw how my general education counterparts did not necessarily always follow the law when it came to providing our students with their accommodations and modifications. So I really went into law to try and help those students originally, but I found that that's a very niche area where there's not a lot of job employment options. So I'm now exploring what other options there are.
Great.
I'm Sam Levitas. I'm a first-year MPP. Right now I'm working for the Department of Revenue as a tax auditor. Before this, I was actually a federal bank examiner for about a year, and I'm here because I'm looking to get out of the whole accounting and finance thing. When looking to get out of this, is I'm eventually looking to be some kind of policy analyst or research analyst, studying the effects of actually socioeconomic status. I narrowed it down pretty specifically. The effects of socioeconomic status on education and on all-encompassing like child health and development.
Great.
So I'm going to be going for public health eventually too.
Thanks, Sam.
I'm Ileana. I'm a second-year MPP at Humphrey. I am doing a focus in education policy. It's also really weird to have a group staring at me. I just looked. I'm focusing on early childhood education. I have an internship right now at Pillsbury United Communities in the Office of Public Charter Schools, so we're also an authorizer. And so I'm learning a lot from that because I've never had any charter school experience before, and I also have no teaching experience. But I'm learning a lot through my internship at Humphrey, so I think my career is don't start after I graduate.
Thanks.
My name is Josh. I'm a first-year MPP student. I don't have any real teaching experience, but I guess you could count a stint with Minnesota Reading Corps. I worked in a school in Northeast, tutoring primarily kindergarten students, and that really spurred my interest in education policy and looking forward to being here. By the way, can anybody tell me what 2L means? Second year law student. Second year law.
I'm Grace Quintana. I am a second-year law student, and I don't really have any teaching experience, but I was a special education assistant at a charter school in law. I'm just in higher education law, so
my name is Nathaniel Beard. Before coming to law school, I spent 2 years teaching at Jefferson Community School in Uptown, one of its part of Minneapolis Public Schools, and I was in a bilingual classroom, so Spanish. And I came to law school to work on issues related to that, immigration, education, etc.
I'm Steve. Close enough come to teaching experience. I think still actively on the roster as a substitute teacher for my hometown, but I never actually taught. I I thought I was going to be a teacher, but didn't want to get a double major in undergrad. I wanted to be done with school. Now here I am. Sorry, my third year of law school, so that didn't work out.
Hi, I'm Olivia. I'm a 3L at law school. I have some teaching experience. When I got to the end of undergrad, I was kind of choosing between education and law. So I taught first elementary school in Dallas, and then decided I wanted to do the policy end, came to law school, and so I've been trying to work education stuff back into my studies. So I did stuff on education and trauma last year.
Thanks.
I'm Kyle. I'm a second year MBE student. Most of my background in education is actually at the technical college level, working with GED and ESL students. So that's kind of my interest.
I'm Lindsay Booker. I'm a second year MBE student and have never taught before, but I am interested in education policy. I have some experience at the National Association of State Boards.
I'm Jordan Root. I'm a third year law student. I come from a family of teachers, so I kind of been introduced to education policy that way.
Hey, I'm Brandon Tice. The job I worked with after undergrad, and I'm still working there now part-time, is Ignite After School, we're an organization that's trying to increase the funding for after-school programs in Minnesota. We operate at the federal level too. So doing policy advocacy for that organization and looking at learning outside of the classroom is definitely an interest for me, but education policy broadly, and just how people learn. So that's what I'm looking at.
And finally, I'm Catherine Tank, KD. I have no experience in the classroom, so I look forward to learning from all of you. But I did work on an after-school program for kids throughout high school and college, and third year law student. So excited to get out of law school for a while.
I've gotten used to the notion that this is a respite from the law school students. So thank you all for that. So I am trying to record this, which is unusual for Humphrey students, but I gather is more common at the law school because we have a couple students who could not make it to the first class for various reasons. And if I succeed in doing this right, then I will continue doing it just in case other students miss it. And I keep forgetting to tell classroom management that it's time to replace this projector. But so forgive the green tinge on the screen. So, gee, that doesn't work so well on the screen. So quickly, what we're going to talk about, we've done the introductions. We're going to talk a little bit about the syllabus and the assignments. Just a couple notes about the calendar that might be different. Then we're going to discuss the readings. And then we're going to do a small group discussion using a World Cafe format. So that's the game plan. We'll take a break. I typically try to organize a break around 7:30. Sometimes if we have guests, so with guest speakers, I have them come at the beginning of class. So I get a fixed time early in the evening to ask them to come. And so depending on how long their presentations go or the Q&A goes, we might end up taking a break around 7:40, 7:45, but typically it'll be about 7:30. That is really, I don't know what is going on. Anyway, so much for trying to use maroon and gold for colors. The first assignment that will be on everybody's radar screen is that next week, by Tuesday at noon, I'd like you to post a short reflection, and this will be a regular weekly occurrence. So a reflection on the readings, and it's in a Moodle question and answer forum. So I have posted a question on the forum, and all you have to do is reply to it. As soon as you reply, you can see all the other replies. Then it'd be great if you would post a short response to some other student's post. My goal in doing this, okay, it is to help make sure people do the readings. But it is also to help create a learning community where there's an exchange among the students, and some really good conversations have gotten going in the past using that Moodle forum. So that's the first thing. Next Tuesday at noon, be prepared to do that. Then the next assignment, which is going to be due September 24th, is a short, like maximum 750 word essay or piece of writing in the form of an op-ed piece, or if for law students, you may not want to do it as an op-ed piece, and you might think about it as an article for a law firm newsletter or something. But if it's an op-ed piece, I'll be kind of wondering if there's a call to action. If it's in a law firm article, you might want to, this is all in the syllabus, but it helps to do this more than one way. You might want to have a piece of advice about, for the client, or the firm's clients, about what they should do. So you get to choose the format. The primary reason for doing that is so you guys get an early read about how I read stuff and comment on it. So you get early feedback that helps you understand my approach to stuff. And because you don't want to wait until the final paper to kind of know how I look at things. So that's my goal in doing this. And I also think that it's important to have this skill. Could also be in the form of a blog post. Then I make an effort to make this course eligible for the second and third year law school writing requirement. A lot of the students who are in this class, by the third year, they may already have met the requirement, so it may not be relevant, but when we created this course, it seemed like a good idea to have it as an option to meet the law school writing requirement. So the paper requirement for everyone is a minimum of 5,000 words, which is the requirement. And the law school also requires, which I think is a positive thing about this, engagement between the student and the instructor in the writing process. So the first step in this paper is to identify a topic and do a rough outline. And that comes up on October 8th. So that gives me a chance to provide feedback on, do I think it's too big? Do I think it's a topic that you can work with? And in the bios, I saw some beginnings of topics. People are passionate about special education or some other things. So this is an opportunity with the research paper to pursue a topic that you're passionate in learning more about. So it's not an assignment, but between next week and the third session, we will go through a process of identifying topics and teams for a team research paper. Or not research paper, research project. And so my goal will be to have those teams be as interdisciplinary as possible, but I don't assign them. We use a kind of a bubble up from the bottom process for trying to get students to coalesce around teams. And so you might be thinking about a topic, in addition to your paper topic, be thinking about a topic that you'd like to do with a group of people over the course of the semester. And then, so with respect to that, I'll be looking for a brief status report on that mid-October. And then the presentations will be in December. The other skill that we want people to pay attention to that is relevant for both lawyers and policy students and researchers is conducting an interview. And so the biggest challenge will be finding a person that you want to interview and arranging time with that person. So don't wait too long. The ideal scenario would be if that interview aligns with your paper or with the team research project that you're involved in. So there's some time before you have to do that. And there's a very brief report format that gives me a sense of what you learned, what you got out of the experience of doing the interview. So it is, you do not have to report on the substance of the interview. I'm just interested in sort of the secondary learning. Then the team research presentations happen in December. And then finally, sorry, I skipped over a step. So a complete draft of your final research paper is due November 19th. So before Thanksgiving, you should be prepared to do a complete draft. Okay. I am realist enough to know that the completeness of those drafts varies a lot, but the more complete it is, the better the feedback you get from me. So what I will do is read and provide comments on those papers so that you have some feedback going into the final paper. So the ideal is that nobody is surprised about my reaction to your final paper. I'll love them all, and everybody will be happy. So then the final paper is due December 17th, which gives me just enough time to do the final read before the grades are due. So the group project, we've had some really good ones. We've had some related to special education, to teacher contracts, a variety of things. And so desegregation. So you should be thinking about something that would be fun to work on with other students. And that is just a presentation where the only submission is the PowerPoint or other presentation documentation. Since we meet on Wednesday night, it would seem cruel and unusual to have class on the Wednesday night before Thanksgiving, so we won't have class. And so we have that night off. But the sort of countervailing thing is, I might not have fixed this date from last year, but anyway, the countervailing thing is that in the law school exam week, we are going to meet for purposes of the presentation. In the Humphrey School, that's the last day of class. But in the law school, it's exam week. So the compromise is that you get this whole semester to do this presentation, and we do the presentation in lieu of an exam on Wednesday of exam week. Okay, so I am going to mute this because you don't need to see this anymore. The law students have heard this numerous times, I'm sure, but for those who haven't been exposed to the lawyer's way of thinking, why read cases? So the short answer is that, as one proponent of the case method of education said, that the law is what the judges say it is. So understanding how judges arrive at their conclusions by looking at past cases and sort of thinking through the reasoning process that the court might have used is a way to think about what might happen in the future. But the other reason, so that's the most important sort of theoretical reason. But the other reason is the practical one, is that in our system anyway, we treat it as an element of justice that there be some predictability to outcomes. There is not complete predictability because every fact situation is a little bit different. The judge I clerked for wasn't big on theory, he was really big on the facts and reached his conclusions based on facts. But he also wanted to follow precedent. So that's another reason to read these cases, that they do establish the existing rule that guides decision-making by a lot of people, including later court decisions. So we spend a fair amount of time in this class talking about cases. The balance is that each week's reading will also include something of more of a policy character. So we don't do the first half on law and the second half on policy. We mix law and policy in each topic. There are some topics that have a little bit less going on in terms of cases. One area, since Olivia mentioned trauma, is that there's like one case that has been an interesting one that dealt with the subject of students who've been affected by trauma and what the education system response should be. That is not a U.S. Supreme Court case, and typically not even a state Supreme Court kind of issue at this stage of the game. But it's an important topic to talk about because it's a challenge that schools all over the country, including in Minnesota, face all the time, is what approach should we take with respect to students who've experienced a significant degree of trauma. So there'll be a mix all through the semester of cases and other kinds of things. So we're going to, in this discussion, at least to begin with, I'd love it if everybody participates, but the law students might have an edge in this discussion, just for a class session or two before everybody gets the hang of it. So we're going to talk first about Meyer versus Nebraska. And since facts are important to these cases, what are the key facts that we should be paying attention to in Meyer versus Nebraska?
Well, Meyer was convicted of teaching other language to a student who hadn't yet completed 8th grade.
Yep. So he was teaching German to a young student, and what was wrong with that?
The state law. The state law provided that you couldn't teach other languages until after they passed 8th grade. I don't know if it was the grade or the standards.
So here we have the interaction of two things, right? We've got a court case, but it is dealing with a piece of legislation that the state had adopted. So the legislature played the initial role in deciding what the policy should be. The policy was that we shouldn't teach other languages, okay? But did the statute cover all languages other than English?
No.
Some, go ahead.
Oh, no, go ahead.
Some languages, like those not in current use, were safe.
Ancient classical languages, were okay. Okay, so that's another piece. That's another fact that came into the court's decision, which was that the legislature did not prohibit some languages, only more modern languages. Okay, then how did this case go from sort of that fact setting to being in the U.S. Supreme Court? What were the steps? David?
Step one was that he was convicted, and I don't know all the names of the local court, and then there was a review or an appeal that he won, I think, and then it went to the Supreme Court.
So yes, so this is a criminal case. He was prosecuted by the state for violating a statute that prohibited certain conduct. And the penalty in this case, as is typical with criminal statutes, is that he could be fined or could be thrown in jail for period not to exceed 30 days. So, today we would call that a misdemeanor, but it's still a criminal conviction. Okay? And so then he won on appeal. So the state said, hey, this is important to us. We want to take this to the U.S. Supreme Court. And why was the U.S. Supreme Court involved in this discussion? Because it started off in the state courts, right? Mm-hmm. How did it get to the U.S. Supreme Court? What was the basis for saying you, the Supreme Court, ought to look at this?
There's a constitutional issue.
So the allegation was, Meyer's defense said, you can't prosecute us for this because the Constitution says he's got the liberty to teach what he wants to teach. And so it was under the 14th Amendment due process clause. All right, now I want to zero in on something here. So due process, okay, when in a typical case, think about what process means. Meyer was charged with this crime. There was a trial, and he was convicted at the trial. So they followed the process. There was a legitimate trial and a legitimate conviction. So any deprivation of his liberty would appear to be consistent with process, right? But there's a second meaning to due process. And that second, so one is referred to as procedural due process, the first part. So the second meaning is called substantive due process. And so what did the courts say they meant by due process in this case? Assuming all the procedures have been followed, what did due process mean with respect to the legislature's conduct in this case?
That is for the former plaintiff's right to teach and the right of parents to engage in and instruct their children.
Yep. But what I'm looking for is, so that, most of the time we're a democracy, we let the legislature do stuff. And only in important cases do we say, wait a minute, you broke the fundamental rule that's in the Constitution. So that is the liberty interest at stake, but how did the court decide whether that liberty interest could be outweighed or not by the state's interest in passing this law? What was the standard the court used? Substantive due process can't be arbitrary. So remember seeing in there the standard that the legislature can't act arbitrarily, and it has to have a reasonable relation to the state's purpose. Okay? So there has to be, so that's in the court's exact definition of substantive due process does change over time. But that is pretty much the core, is it believes that the state, the legislature, can't act arbitrarily, and there has to be some reasonable relationship between their goal and the measure that they adopted. So why in this case was this law deemed to be arbitrary? What did you see about Sam?
Because not all languages were prohibited.
So that's one reason. Yep. It certainly helped to make it look kind of arbitrary. Was that if they really wanted to make sure that kids learned English, they wouldn't let the school spend time teaching them Greek. So that really, I think that's a fact that's pretty important to this. But let's assume for a second that they hadn't made that exception. Do you think the court would still have come down the same way? So there was the liberty to teach what this teacher wanted to teach, right? So his liberty interest was most at stake because the state was threatening to throw him in jail for what he did, right? So a pretty clear connection between his liberty interest and this statute and the Constitution. But were there some other liberty interests at stake here? If so, whose were they?
It's the child, the liberty of the child to learn another language,
to acquire
to
knowledge.
acquire that knowledge, and there was no, the state had no reason to restrict that. And
Yep.
there was no justifiable cause to identify that as impeding the educational process for the student.
Right. So the teacher's got a liberty interest to teach. The student has a liberty to learn. Anybody else? Yeah, the parents get to have some degree of control over the child's education. We'll see that more later. And so there were a lot of liberty interests piled up against the state's interests. And how did the state defend what it was trying to do? Is there an argument that they made that seemed appealing to you?
Definitely didn't see the feeling. They argued that it was injurious to the child's mental health or development to learn a foreign language when they're supposed to be being brought up in the ideals and language of their home country, and that the state then has a right to prevent that from happening so that they'll be more mentally healthy and well developed by now.
And the state also argued there was a desire for homogeneity of instruction of the educational process for students.
Yeah, and what was homogeneity going to buy them? I mean, that's a means to an end, right? What would the consistency or homogeneity in instruction get the state if that's what happened? Anybody?
I mean, they want all the students to be equally prepared and equally functioning within the society, within the city.
So equality, so consistency or similarity in instruction helps you deal with the question of equality, but it also helps you get social cohesion, at least in theory, right?
Yeah.
And so we're going to see this question pop up over and over again, is that states, governments, like the stability and cohesion and tend to do things that push in that direction. And we have values embedded in the Constitution that put limits on the ability of the state to achieve its goals with respect to social cohesion or homogeneity, and argues for more heterogeneous kind of approach to the way people live together. So that's a tension that's going to show up over and over again, is this one between the Constitution's interest in diversity of experience and diversity of choice, and the state's interest in bringing people together and having a stable and prosperous society.
I mean, what's not in here though is that the context of this is 1923. It's just after World War II. World War I, and this is a German-speaking instruction, so that's not written here, but I'm sure that's the backstory behind prosecution.
I think it says unfortunate experiences during the war, aversion toward every character.
That's right.
How do you pronounce that? Adversaries. Certainly not to put them that aspiration. So that, to me, says that statute came out of just nativist sentiment after World War I.
And when we get to the free speech cases, we'll see that with respect to World War II as well. That conflict seems to strengthen this response in the legislature. And the question is, at the time of conflict, to what extent is the court willing to stand against the popular tide, right? Because the legislature wouldn't have done this unless they thought people in the state wanted it done. They were responding to what they were hearing from their constituents about it. Right? There was a movie set in Minnesota during World War I called Sweetland. Has anyone ever seen that? So essentially, it's a German mail-order bride who shows up, and her difficulties in being accepted in the small rural farming community, and it gives you a sense of what it might have been like for communities and for their elected officials at the time of this. At the time that people were dealing with World War I. So we're going to come back to Danielle Allen, but one of the things that I saw in this case that I hadn't spotted before because I hadn't read it in conjunction with hers is the language the court had basically about how one of the goals of education was to enable students to be ready to participate in the political process, and that knowing German probably wouldn't be an impediment to their ability to participate or be ready to participate. And so it's interesting to see that language. Okay, Pierce versus Society of Sisters. So what key respect is this different than Mike?
This has to do with compulsory
And anybody being thrown in jail? Yes? No. So in this case, it was the nonprofits that started this. The legislature adopted the compulsory attendance. Well, actually, no. This path, Oregon has initiative and referendum. So this was adopted through initiative. The people adopted this in a vote. It can be problematic because sometimes the people don't think about the constitutionality of the things that they do. But anyway, so this was adopted in an initiative, and as soon as it was adopted and before it could be enforced, the nonprofits sued, the schools sued, saying, this is going to impinge on our liberty interests. Okay, we can't throw a school in jail. So how is it going to impinge on their liberty interests? Good question. Yeah, and collecting money. So there's a liberty interest in property at stake in this case. And so the court was trying to look at, does this impinge on that? That's the consequential effect. And what were the arguments made on each side in this case? What was the state's argument for why kids should be required to go to school?
Because to do otherwise would deprive them of education.
Yeah, and what was the report said? Talked about the importance of an education. What did they emphasize? Participation in civic affairs. So one of the interesting things about that we'll loop back to a little bit is that in Meyer and Pierce, you don't see a lot of emphasis on students being prepared for economic success. We're not talking. The court doesn't say they got to go to school for workforce training, to use a current term of art. They talk about the student's role as a future citizen, and so that's the interest that they're trying to defend. And what was the interest on the other side?
The schools were saying that it's that would deprive them of their business, of their livelihood, that they're providing a service, and that that would basically end their business, and that that they're not doing anything wrong. They're providing a service that meets the needs of the students and of their parents, and there's no just cause to stop that.
Yeah. So, this is not the earliest, but one of the early cases where you can see corporations or organizations being treated as if they were people with the same rights under the Constitution as individuals. But there's another, again, as in Meyer, there's another set of interests at stake. Who is interested in safety?
It's the parents and their upbringing. Although I have a quick question, since you're in Meyer. What's the difference between vital control and putting the parents inside education? Are they one and the same? I don't quite understand.
Some legal philosophers would argue that there's a distinction between a freedom or a privilege to do something and a right to do it. But often the courts don't observe a fine distinction between a liberty on one side and a right to something. And so you can't be deprived of liberty, life, liberty, or property without due process of law. That means you have a right to party. You have a right to life. You have a right to be free from arbitrary impositions. Sometimes this gets back. Yeah, another. I'm like remembering back to law school, somebody who had this whole framework around the difference between privilege and freedom from. And we don't have to. Okay, so this is a civil case, not a criminal case. The institutions were trying to stop the state from enforcing this before they did anything. And the other interest at stake is the parents' right or the liberty to direct the upbringing of their students, of their children. Okay, so Wisconsin versus Yoder brings us closer to the modern era. And so basic setting for this case.
So the students were Amish, and the state was asserting that they needed to be continuing on until 18, and the Amish community wanted them to go withdraw them from school at age 16 to be.
I think it's earlier, 14 and 16. Yeah,
and continue their. They wanted them to, the Amish, having them do early school learning to read and write, but then for those last couple of years there. So the state was saying that they were in violation of the compulsory education.
Yeah. So it's different from Pierce because the Amish students, Amish young people, are not going to go to school.
Right.
They are going to engage in informal learning, essentially with their parents on the farm. And so it doesn't show up. The interesting question whether if somebody had offered a Amish religious school option, would the court have said, oh yeah, they got to go do that. But the Amish don't operate a high school that is consistent with their religion. So the court was stuck with the situation of trying to decide between school or not school. And so that made this one a little bit more difficult. But again, this is a criminal case, so arguably if the kids didn't go to school, was anything going to happen to the kids? The parents are going to get thrown in jail. And in this case, the two dads.
For failing to cause the child.
Exactly.
Cause the child.
Yep. And so the court spent a lot of time on this. Okay, all right, so what's another key difference here? Okay, 14th Amendment's involved, but what else is involved? Yeah, so the First Amendment is involved too. Okay, so I lose track of what gets covered in civics or political science in undergrad. But anyway, the original Bill of Rights only applied to the federal government. And until the Civil War, that was the case. And then when the Civil War amendments, including the 14th Amendment, were adopted, you had the application of, because it says that no state can deprive people of life, liberty, property without due process of law. So the Supreme Court determined that the 14th Amendment brought the Bill of Rights into application, not just to the federal government, but to the state governments too. So you had this historical result of strengthening the restrictions on government action, not just at the federal, but also at the state. So, so the state can't do this, the Supreme Court said, but they spent a lot of time talking about the Amish religion. Why do you think that was?
They need to establish that it was a valid religion, not just a whim.
Yeah, and so say some more. So expand on that whim part, right? If it was a whim, what's the downside for them?
That it would then, I guess, be applied. Like anyone could then kind of come across and create something to be able to get around it.
People would be inventing religious practices of all sorts that made sure that they wouldn't have to go to, the kids wouldn't have to go to public school, right? The court was sort of staring that sort of practical effect in the face and saying, all right, I got to, set up this big wall that basically says this works for the Amish, but not for every other religion that, comes up and says, we don't want kids going to high school. So Justice Berger has to work pretty hard to reinforce the specialness of the Amish case so that it doesn't show up in a lot of other things. Yeah.
No, I got it. Now I understand. Now I get the point. Sorry.
Yep.
I mean, he's laying the ground. He's basically laying the groundwork so that can't be used as groundwork for other cases.
Exactly.
It has to be very explicit.
It's really hard. It's always a precedent, but meeting the standard of, like he talked about, 300 years of experience, right?
It's hard to fake that.
Yeah.
It's hard to say that. So
right. You kind of prove your religion has got decades of following the same practice before we'll think about it, possibly creating an exception for you as well. Okay, so another concept that's going to show up in other cases. In Meyer, one of the things that showed the court made the case, the legislature tried to make the case. The state said, we are protecting the safety of the students, right? So that's an exercise of the police power. Governments under our system, the English system, have had for hundreds of years, the police power to protect the safety of the people. And that shows up in lots of different applications. For example, public health. You can require individuals to get a vaccination because it protects the public health. That's a legitimate exercise of the police power. And so the state in Meyer was exercising its police power to regulate the overall safety. But in this case, the state tried to make an additional argument beyond the police power with respect to the adoption of the compulsory attendance law. So what was that additional argument? Okay, so it might have gone by a little fast because it was in Latin. The
parens patriae?
Parens patriae.
But isn't it the same as isn't that analogous to the police power of the state?
It's a little bit different because in this case you're not protecting the safety of society. You are stepping in as if you are the parent of the child. So the state is asserting that it, in essence, can step into this situation and act as if it is the parent, and therefore has more power with respect to the welfare of the child.
How is that different from like in local parentis, which I've seen in school handbooks, like when I was in middle school, high school, in local parentis was in the handbooks. How is that different?
Okay, so I haven't thought as much about this recently, but I will. So any of the law students who have a more recent, schools for a period of time have custody of the child.
Okay.
So during that time that they have custody, they are in local parentis until they can get the parent back involved in the decision-making process. So they have to have some, in an emergency, they have to have some ability to act. And so the in local parentis enables them to do that. In this case, the parens patriae tends to be a more deliberative or considered process. And one of the places where this shows up is in the health in disputes over the treatment of the child. Mm-hmm. So the cases that have involved mandatory health treatment for sick children. In some cases, Christian scientists debate about whether it's a violation of the First Amendment to require treatment of a sick child against the wishes of the parents. In that case, the state could go in and say, we're acting in the interests of the child as if we are the parents. Even though there's an argument with the parents over the treatment of the child. So the state, in this case, tried to argue that parens patriae applied, and the court said, sorry, that theory doesn't work either. Because it does not, again, Berger went to work science for years, and what can they learn in 2 years anyway? And so all this sort of minimization of the benefits of 2 years of education to make this look minimal. Anybody know where Warren Berger was from? So he was a lawyer in St. Paul. He grew up here and was involved in the political process. So to some people who aren't from or haven't spent much time in Minnesota, just as Wisconsin does, in that region of the state where southeast Minnesota and Wisconsin both have a large Amish population. So Berger was active in politics, and it's not too hard to assume that he had some firsthand contact with the Minnesota Amish community. And so, may have had an easier job writing about this than somebody who wasn't from Minnesota, Wisconsin, Pennsylvania, some other places where there's a significant Amish population. So I don't know that, and there isn't much commentary about that, but But it's one of the things I've wondered about, whether his own experience affected what would be appropriate, the writing in this case. Okay, so before he was done, he sort of did some qualifying work. And what was that? Anybody notice that? So they've just gotten done interfering with the rights of the Wisconsin legislature to govern the education system in Wisconsin. And he says, we shouldn't generally do that. This was an important case where we had to do it here, but courts should not lightly interfere with the ability of the states to govern this, no?
Where he's basically saying you really should say one group is right and another group is wrong, and he's like groups should be condemned to just leave their friends.
Well, I think there he's reinforcing sort of the pluralist view of America that shows up in Pierce, right, where people should be able to go to different kinds of schools without being told to go to this school. But he's also saying that that in general, education is one of the top priorities. He said it's at the apex of the obligations of government. And therefore, when the courts do interfere, they shouldn't do it too readily. So another of the reasons he spent so much time talking about the Amish was to justify why the court was stepping in this case. You see this sort of tension or balancing act that the court's trying to do between the democratic governance of education and the court's desire to enforce the pluralist, somewhat more libertarian interests in the Constitution. So Justice William Douglas dissented. What was Justice Douglas's argument?
William Douglas, who was also from Minnesota, didn't live here but was born here. His argument is that we have to pay attention to the interests of children. And so on the one hand, while the parents, of course, have a right to have some interference in how they raise their children, the children should have some, the state should also look at the interests of the children themselves. While one can understand why an Amish community would want to raise Amish children, we don't know if the children themselves want to be raised or become Amish down the road. And so Douglas said if he was writing a majority opinion, he would suggest taking it back down to a lower level, bring the children on the stand, ask for their opinions. Who knows what weight may be given, but that's the process that should be followed.
What do you all think of that?
I mean, what are the children going to say if their parents are included?
Darn good question. Darn good question. And, if the parents have done a good job, the kids probably would have said, I don't want to have anything to do with those darn English. Yeah.
Well, I mean, I'm thinking about topics and it's not like law or anything, but there's like this thing called brunch dinner or something like that, the Amish religion, where the kids are able to like go off and live life or something outside and live the English life.
Like
in Pennsylvania, so there's like a high population of Amish in Armstrong.
So Lancaster County?
Yeah, like an hour from there. So like, it's like they have their time to go out there. I don't know if it's like a great time for it.
That is like,
yeah.
Trial that exists.
Yeah, they go out and live their life, but they decide to like live that life.
So one of the questions, right, is does the court, is one of the consequences of this is that before you can decide how to apply the statute, you'd have to invite every kid in, right? And so every year there'd be a new crop of kids we're testing to see whether they want to go to school or not, and before they do the experiment. So I mean, it's really a great theory, but one of the things to watch for in these cases is, in terms of the arguments that lose, is what's the practical implication if it had won? And it would be really hard, not just for the kids to be candid, but administratively it becomes, do we have to do this with every batch of kids, or is it just that this batch of kids gets to decide the precedent for all future Amish kids? And yeah, I don't know. I'm not sure what Justice Douglas was really thinking about. But I moved. So this year, because I got really excited about Danielle Allen, I moved John Dewey, who I also like a lot, to the optional readings. And Douglas's opinion is really consistent with John Dewey's approach to education, which is that the students ought to have as much control over that education as possible. That if we expect students to become effective, self-reliant citizens, they shouldn't be entirely dependent throughout their education process. That there needs to be this process of increasing their control over their own education. And so there are big echoes of Dewey's approach in Douglas's that I think has been interesting. Okay, so we are going to shift over to Danielle Allen. Okay, first time I've used her in this class, so I'm going to ask an evaluative question right at the beginning. Thumbs up, thumbs down, pretty good. Didn't understand her. Okay, so I see more up than negative. She does a pretty good job of summarizing a lot of trying to bring into a system of thinking a lot of the issues that we'll talk about later on. Okay, so when she talks about two levels of justification, what does she mean by that?
So she references the idea of the two concepts, and she cites the political theorist John Rawls. And her argument is that when it comes to a lot of public discourse surrounding justifications for education, the discourse is very muddy because people aren't using terminology correctly, or at least when you say education, people have different interpretations of it. So the two tiers are, what is the broader social justification for it, in which case you might make arguments that are economically utilitarian, or you make more individualized human experience arguments. And that's where, and she focuses, at least on the excerpts we've read, on the latter category of the individual justifications, development of the human, side of human flourishing. She uses the term of the humanistic baseline, which I don't really know what that means, and she talks about participatory readiness.
Yeah, and so there are two. Here's another way. That's right, I believe, and here's another way of saying it that I also later on can understand is that the first level justification helps explain why the state should be involved in this practice of education. Because initially, in the United States and in other parts of the world, the state, or our notion of the state, was not as involved. It was the church, it was the feudal lord, it was other institutions, and it wasn't the state, or the sort of organized government that was involved. And so the first level justification helps explain why the state should be involved in education. And then the second level justification, the humanistic baseline, another way I think of that is it's why do I teach? Okay, yes, so up here I want everybody to go out and get good jobs and to be active citizens, sort of that utilitarian thing. But, I think most people who teach like to see the change in the student from the beginning of the interaction to the end of the interaction, right? That the reason for teaching for most people isn't up here, it's the personal growth of the student and of oneself as a learner theoretically doing the teaching. So I think of that as part of this humanistic baseline too. And she may be making this distinction in part because of her perception of the strength of the utilitarian arguments, right? Particularly the utilitarian argument focused on economic success, what she calls the neoliberal argument. Because, and so she's got the Obama and Romney sort of side-by-side examples, and kind of sound the same in terms of the rationale for why we educate people. And there wasn't much citizenship in those statements.
In the competitive global market.
Yes. Yeah. Yeah. And that's the debate right now, right? When you look at some of the discussion, particularly in the op-ed pages over the last few months in higher education, the debate is, okay, should more students go to 2-year colleges or as opposed to 4-year colleges? That's kind of a poverty-stricken debate, first of all. Can we debate more fundamental issues than that? But the debate is which one is better for students getting a job, right? And missing from that discussion about 2-year or 4-year is which or both are best at helping the individual human being thrive. If we don't treat the human being as a cog in the future workforce, and treat the human being as an end in herself or himself, which one is better? Is there one better than the other, or should there be other opportunities? And that is not shown up. So this distinction she's making, I think, is a reaction to what she's seeing in the conversation today. And so that this two-level distinction might be theoretically right, and she might have come to it in another environment, but this environment sort of pushes in that direction. She's a philosopher, humanist in terms of her academic background, and so she also is pushing back on the utilitarian arguments in favor of the humanities. So at the beginning of the second lecture, she recaps something that I didn't have you read in the first lecture, and that is sort of her use of Hannah Arendt to arrive at basic needs. So those are
one of the things is that political participation is a part of flourishing life. So it's a need. It's not just an extra.
Yep. So that's one. There are 3 others. Breadwinning work. Doing work that helps you keep alive. What else? Yeah. Rewarding relationships, intimate and others.
Creative self-expression.
Yeah. Okay. So we see much of creative self-expression or developing relationships and the rationale for education conversation. Yeah. No. So she really is sort of challenging the current state of the discussion about the purpose of education and carries it much further than. So we're going to, our discussion after the break will focus more on the state constitutions, but she goes beyond the 2 example constitutions in talking about the purpose of education in a much more humanistic way than those constitutions do. So in another part that you didn't read, I just want to call this out in case people have time to go back and want to take a look at it, is that she also has a short section on how we can evaluate public policy with respect to education. And we can evaluate, because of this two-level rationale, we can evaluate it on whether it's meeting the social goods. So is education delivering students who can be effective breadwinners? And is it delivering students who are capable of civic and political engagement? Okay, that's one level. But then the second level is, are the students capable of relationships and the other kinds of things? And so what we will talk about assessments of students and of education, and her thinking about that does not appear in any current practices related to assessment, at least not yet. We're starting to move in that direction with respect to social and emotional learning and attending to the emotional effects of trauma and things like that, but we do not evaluate schools on the humanistic contribution that they make. We do on the math and reading, which arguably contribute primarily to the economic contribution that they make. So why does education relate to equality? We talked a lot about sort of the liberty interests and stuff that are involved in education, but why does education relate to equality? Way of thinking?
She says that education should prepare students for political participation, economic and social.
Yeah, which is kind of a different formulation than we also see right now, because when people are trying to talk about how we address income inequality, one of the issues, right, is the achievement gap that we have, and how we can do a better job of preparing low income or kids of color to be more successful through education, to be economically successful. She doesn't deny the importance of that, but she also said if we worked equally effectively, or even more effectively, on the political skills, not just the economic skills that students would learn through education, that they could change that society in a way that would make their economic development more possible. So that's a much different argument than we'll see in other settings. So finally, on her, she talks about, so when she talks about this civically engaged person, what kinds of roles did she separate?
About the civic leader, an activist, and the politician.
Yeah. And she happy with the current state of affairs for any of them?
No.
Yeah. She said, okay, we used to have statespeople. They would combine sort of the civically engaged citizen. And one of the characteristics of the civically engaged citizen is disinterestedness. Right? So you are not politically active because it will benefit you personally. You are politically engaged, civically engaged, or politically engaged because of the common good. And that she doesn't, so she doesn't call this out, but that rhetoric goes right back to the founders, because the founders talked about the importance of people being disinterested, and you make arguments that these white male property owners were not really disinterested, but they at least held that goal out for themselves in their rights. and so then you have the activist. And the other, part of the description, did anybody's ears perk up when they heard the activist described as being in prophetic mode? It's like, that sets a pretty high standard for the activist, right? It's like, you are describing the future that you're working for in a way that is in the category of prophecy.
Utopian. I mean, not really,
Well, but she talks about it as reframing.
She doesn't say that, but
yeah. So she talks about it as reframing. So, I'm trying to, okay. So, use a really old example. And so, regardless of other faults, when John F. Kennedy said, "That's not what your country can do for you," he was reframing the role of the citizen in a somewhat prophetic mode. And there are, Martin Luther King Jr., arguably in the same way, he kept trying to reframe, and he used sacred language to reframe the relationship between whites and blacks in the U.S. And so there are examples of that. They're not super common, but the goal of these. Okay. Right now, we could really use somebody who can reframe the relationship between rural areas and urban areas, right? The depth of that divide calls for something more than a disinterested, civically engaged person, and arguably is exacerbated by professional politicians. So, that would be one of my current examples for a place where we need somebody with activists or reframing kinds of skills. So I thought those were the identification of those roles, and her talk about the fact that ultimately what we're trying to do is the capacity for mutual world building. That's a pretty big goal for education. Certainly, I treat it as a challenge. Later on, we'll talk. When we do talk about some of the innovations that involve more student direction, I treat that as a challenge too. So, a reminder: if any of you have suggestions for things we should be talking about, where you would feel more in control of your education, you should let me know, and we'll figure out how to incorporate it into the semester. Okay, so let's take a 10-minute break, and then we'll come back and go through this exercise with the state constitution. So forgive me, I was late in starting this, so you missed the introduction to the World Cafe exercise, but what I'm going to do is try to put the laptop where you can hear a specific conversation.